Good afternoon and welcome to the Cordell and Cordell National Webinar dealing with coronavirus, COVID-19, and how it affects guys facing divorce, in the middle of a divorce, perhaps after a divorce, or even just thinking about it. You know, we wanted to gather together some of the attorneys from around the country to bring to you to answer your questions. For the last several weeks, we've been receiving questions from around the world, including our offices in the UK, just asking, what can I do? And so we thought what would be better is to bring to you some of our attorneys from around the country. It's the benefit of having offices around the country in 37 states and over 100 plus cities and locations near you. So I'm Scott Trout. I'm the CEO and managing partner of Cordell & Cordell. Before we get started, some of you are familiar with the webinars that we often do, or the podcasts, or the lunch and learns that we give around the country. Keep in mind, disclaimer here, and it's extremely important, that this is not legal advice. We don't want you to take it as that because we don't know your circumstance. We don't know the particular facts about your case. That's so important. We wanted to gather today to try to give you information, boots on the ground. We want to try to lead you in the right direction, create some talking points, some action items, and some to-dos for you to take to your attorney or to find an attorney. Obviously, we're here to help you and serve you around the country if you need us. You can always find us on the web at cordell.com or 866-DADS-LAW. You can check us out there. But today we've assembled a great panel of people to help. But keep in mind, there's some things that we're going to answer for you. And I want you to take a pen out and a piece of paper and write these down, because if we haven't answered these, then obviously we want to make sure we get to it. But these are the three real critical questions for guys facing these issues in this crisis that's really not just in our country, but around the world. And that is, what can I do? What should I do? And what must I do? Those are the three elements that we're going to cover throughout today as we go through a number of different elements that affect divorce and guys contemplating it, or perhaps you're finished your divorce and you have a lot of questions. So, you know, let's get to assembling our panel, introduce to you who we've got for you today to bring you the information that you want and the questions that you have provided to us. So first, joining me on set today, I have Dan Cuneo, who is a partner in our client development team. Dan is licensed in Missouri, Illinois, and North Carolina. Welcome, Dan, to the program.
Good afternoon. And one thing I want to echo is we are in unprecedented times, which doesn't mean that you cannot see your children or that there may be no remedies available to you. So Scott makes a really good point that start jotting down some notes that you can reference later, and especially, more importantly, take these notes with you when you schedule a consultation with your attorney. We are offering virtual consultations or even consultations by phone if that's easier for you. I receive a lot of questions as far as, what can I do now? What is the best way for me to protect my family? And I just want to jump right to it because I'm sure a lot of you who have logged in have limited time. And so a couple practical tips would be, one, make sure you're sanitizing all surfaces that are used quite often. Two, you can practice good washing your hands with your kids. 20 seconds is what the CDC is recommending. Another question that comes up is, how do I talk to my kids about this? It is a very sensitive topic, and we want to be careful because we don't want your children to develop a lot of anxiety and be scared, but we also want to be open and honest with them. So make sure that you set time aside to talk to them, make sure that you're open and honest with them, but you want to make sure that the communication you're having with them is appropriate for their age. The other thing that we want to make sure that we're cognizant of is how we're disseminating that information to them. We do not want to blame anybody else because you don't want to set any type of stigmas that can maybe come back down the road and they go and tell mom that, well, dad's blaming this group of people or this person on this, and that may not be looked upon as in the best interest of the child or fostering a good environment. Another question that comes up is, well, what about activities for my kids? The one thing that I'm advising all of our clients and potential clients who come in to meet is routine in these types of times and these types of situations is essential and crucial. What we want to do is make sure that we're trying to keep the routine the same, which would be bedtimes, dinner times. Another activities that we can do with the kids to try to keep some routine is going outside, going to a park if they're open. We want to make sure we're complying with local laws and regulations, but also the social distancing. Another thing that's important to keep in mind is we still want to foster a good relationship with the other parent. And so we want to try to utilize FaceTime, Skype, Zoom if it's available to you. Make sure that we're still keeping in touch, and that means with grandparents and other family members during these times of quarantine. But the most important concern that comes up in a lot of our meetings with clients and a lot of potential clients who come in, they're concerned because the other side is taking advantage of the situation. And that's something that we really don't want to foster, and that's something that a lot of courts just have zero tolerance for. But the issue that we're running into is we see a lot of these shelters in place and a lot more restrictions coming down from city governments, that the courts are really restricting what can be heard. And so and we'll talk about this throughout the next hour together, but I want you to know that it is important that if you're being denied time, there still may be remedies available to you. So we want you to reach out and contact an attorney and discuss what are your options, what do we need to do. And it could depend upon the jurisdiction that you're in, if you're filing for an adult abuse, if you're filing an order of protection, if you're trying to get an order in place for you to see your children. Those are essential remedies that are available that we want to make sure that we're taking advantage of. You're not just sitting back and missing out on time. And on the other side, we still want to foster that relationship with the other side. One thing that comes to mind, Scott, is California was one of the first states that really kind of shut down. And my concern is that we have dads out there who may not have access to their kids. So I was thinking maybe we go to Jason to kind of get his thoughts on what he's seeing since he's up there in our Sacramento office. Jason.
All right. Yeah, guys. So here in California, we've been subject to a shelter-in-place order for a little over a week now. We're already seeing our prospective clients and our clients affected as to their ongoing custody and visitation concerns. I've had a number of existing clients and a lot of prospective clients who've already reached out as to how does this affect me? You know, how does, if I have an opposing party who's telling me, look, I can't see my kid this week because they're concerned. And you know, the general advice that we're giving in these very uncertain times are use common sense. The standing order from almost all of our courts are that the existing orders are to be followed. Parenting time and visitation is deemed essential travel. That's not within the confines of the shelter-in-place rules. So it's a developing situation. It's something that we're seeing somewhat modified as far as the guidance from the courts on nearly a daily basis. But for all intents and purposes, we think that this really should be business as usual when it comes to enforcing and exercising your visitation, obviously with common sense, given the circumstances.
Sure. One of the things that I think that we want to focus on is, or what are the remedies available to you? And I was thinking, Scott, since a lot of the courts are really restricting what we have, should we go to Rick to see what his thoughts are?
Yeah. I think it's a good time also. Let me introduce the panel. So guys out there know where we are and who's talking to you about where they are in the country. You heard from Jason, who's in California. He's a lead litigator with us and been with us for over 10 years. You probably have seen him on Fox News and interviewed in the Wall Street Journal. He's also licensed in the U.S. Supreme Court. That's Jason out in California. We got Rick Julius. Rick, who will talk to you next, is up in Pennsylvania. Rick actually has been with us for over 8 years, admitted to the federal court system and the Court of Appeals in the Third Circuit. He's a partner, a litigation partner with Cordell and Cordell as well. The final two panelists we have today, we'll go with Kelly Burris. Again, another early state that adopted a shelter in place. Kelly's been a partner with Cordell and Cordell. She's been with us for over 12 years. The unique thing about Kelly is that she's board certified in family law by the Texas Board of Specialization. So that brings a very unique aspect to our panel today to give guys out there the best advice on the ground. And then rounding out our panel is Kristen Zurich in St. Louis, Missouri, who's also a partner on the litigation side. Kristen's been with us for over 13 years, and I know you've heard her with numerous interviews on the radio talking about guys and divorce and custody and support issues. So I want to thank our panel joining us today, but we can kind of turn it right back to Rick Julius up in Pennsylvania. Rick, kind of just give us a quick overview of what's happening, and as Dan kind of introed it, in terms of some of those practical tips, kind of maybe give us the perspective of what you've got up in Pittsburgh.
Thanks a lot, Scott and Dan. In Pittsburgh and in statewide in Pennsylvania, we've had sort of an ever-growing, rapidly evolving set of orders that have come down both locally and statewide that have kind of given us a little bit of the progression of what we might see in other states as far as access to courts. Our early stage shelter-in-place rules and business closure rules didn't have a whole lot of detail with regard to access to children, standing custody orders, and so on. Our Supreme Court had to come back and actually clarify to make sure that we weren't changing court orders via the governor's regulations and all of that. So I think Pennsylvania, given the kind of slow evolution to how things have taken place over here, mostly with the early cases as of two plus weeks ago being in the Philadelphia area, and then spreading over toward the Pittsburgh area on the western side of the state, have given us a little bit of an idea on what are the problems to look for. So we want to make sure that you have a clear dialogue and open communication with your attorney. Make sure that you know your standing order or make any adjustments to your standing order with regard to custody ahead of time so that we can address some of these issues, and make sure that you're getting all of the information and communication from folks like your children's doctors, your school, your children's school, being in touch with your attorney, with folks in your local municipality. There's things that tend to come out ahead of time that you only have a few hours to act on in terms of access to courts and some of those items. So,
yeah, thanks, Rick. I think what kind of a great segment as we talk about what's going on in certain aspects of the country. Every guy's out there wondering, I've heard the shelter in place. Kristen, guys are saying, well, what can I do right now? Because I've heard everything's closed. I'm sitting here, in Missouri, we've got an order that's come down about a shelter in place across the country and specifically in the counties, and the courts are closed. Guys are worried. They're either thinking about filing, they are in the middle of a divorce, or much worse, they need to do something. So maybe, Kristen, you can help guys really give them the answers here, at least from the Missouri perspective. What can they do right now from a court access perspective?
Sure. Thanks, Scott. I'm glad to be here and give my Midwest perspective as to what's been going on. It's important that you guys know that courts, at least where I am, aren't closed completely. So in-person court is banned. And so if you have a case where you're supposed to be seeing your children and the ex-wife has cut you off, we can't run full throttle into court to file anything and get in front of a judge immediately. But our courts are still open for filings. So it's important to know that if something is going on and you want to bring it to the judge's attention, go talk to your lawyer. You have the ability to upload pleadings to the court. The judges have been looking at everything, but their determination needs to be whether or not it's an emergency that requires a phone conference or a video conference to deal with it, or whether it's something that's just going to have to wait until court reopens. So the hard news I have been having to tell people is just because it's an emergency to you doesn't necessarily mean it's an emergency to the court. So know that even if the judge isn't going to get us in on an emergency teleconference, the issue becomes you could get heard as soon as court's in.
So really, let's look over to Texas. Kelly, what's going down in Texas? We get Kristen's perspective, that we at least know, it's not when we think the word closed, meaning that, nothing can happen. We know that guys can file things. What's going on the ground in the court system in Texas?
Well, it's similar in that, the courts are closed to some extent for in-person, non-emergency matters, but some judges are hearing emergency matters. So temporary restraining orders, protective orders, anytime there's a family violence issue or concern about the child's welfare. Now the judge makes that decision as to whether or not that's an emergency issue. So our stay-at-home orders here and it's certain regions, some of the outerline counties are still completely full and open and and ready to have hearings. But most of the major cities have closed down. So but the judges make those determinations as to what's an emergency. And even if the court decides that it's not an emergency, again, we're still open for filing. So if you have a really important issue that you feel like needs to go to the court, but the judge doesn't necessarily think it's an emergency, it's still important to get that on file as soon as possible, because you don't want strategically the court saying, when you do get into court maybe 2 months from now, going, well, you must not have thought it was that important because you didn't file anything. So, it's important to get stuff on file and see what options you have, especially if there's a concern regarding safety. And some judges are taking things by submission. So, for example, I have a hearing right now that we're going to just submit it by email. And then the court's going to make a ruling based on argument by email and the orders we submit. So, it's important to consult your attorney to determine what your options are here as well.
It's a good point, Kelly. Kristen, let me come back to you. I really am curious because I know guys are sitting there. We talked about what can I do as the first question. And, this is a great starting point because it's really the access to the courts. No one knows what to do. I mean, we have never been in this situation, not only in our country, in your state, but around the world. So, Kristen, as Kelly was talking about filing and some not in-person access, guys are asking right now, hey, you know what? We have clients coming into Cordell & Cordell. Still, we had 600 consults this past week. Guys are wanting to file. Can they do that? Can they still electronically file? And if so, what's the importance of taking action now?
Sure, absolutely, Scott. To the best of my understanding, we can still file. It becomes a question of in each jurisdictional court whether or not they're issuing summons to be served based upon the lockdown orders. But for all intents and purposes, you can go to your attorney, get your divorce drafted, get your divorce on file. So if you are thinking about filing or you're on the precipice of filing, why don't you use this time to make yourself the best client in the world to your attorney? There is nothing that makes attorneys happier than when you hire them and bring them really organized information. Use this time to download your tax returns and 1 year of all of your financial statements onto a jump drive to be able to give your attorney. Heck, filing now makes an awful lot of sense while all of your assets are depreciated because of the downturn in the market. This is also a pretty meaningful time when everybody's just sitting at home to start gathering your evidence. So if she's not letting you see the kids right now, by all means, download your text messages and give them to your lawyer. If she's home and she's bored, so I have to assume she's posting on Facebook and Twitter and Insta and all over the place, screenshot what's helpful to your case and give that to your attorney as well. So even though we're not involved and we can't go to court right now, this is certainly time you can start to get some of the dominoes knocked up to be able to make sure that your case can fall in the way you want it to fall.
Kristen, you make a really good point in the fact that we always advise all of our clients documenting is key. We really want to be prepared and proactive. But in these types of situations, gathering all the documents and then scheduling that appointment with your attorney to review them, because you mentioned earlier, there's going to be depreciation. There's going to be a loss. This may be the most opportune time to gather all that information and get something on file. So you raised some really good points, but the other concern that a lot of clients are having is, what is this access like to the courts if my case is deemed an emergency? How long do I have to wait?
Sure, and if there is an emergency and the court takes issue with something that needs to be done right now, as I've been seeing it, at least in my jurisdictions that I practice in, the courts will reach out to the attorneys directly, try to set a time for a phone conference or a video conference to deal with things in a hearing in that manner. I'll be honest with you, in terms of honest to God emergencies I've seen in the last 2 weeks have been very small. Judges are frankly just putting things in line to be able to deal with them once the courts reopen.
And another good point, just going back to the planning, because it is so important during these times of hardship. We need to make sure that we're gathering all the documentation, because you made the great point that aids and assists your attorney in determining the proper time to file. Another issue that was raised by our panelists is we were talking about the misconception that courts are closed. It's not that the courts are closed. There's a lot of restrictions on what can be heard. But I want to go to Kelly and see what she's seeing down in Texas and give some really good advice on the educational side, because There are schools that are closed, and there's parents that are having to homeschool for the first time. So what tips can you give some of our viewers out there as far as what can they do now that the actual school system is closed?
Well, I would certainly fall into that category of homeschooling for the first time. So it's a new experience for all of us. And I think we've all been valuing more and more what our teachers and daycare workers bring to the table during this time. The point is, though, to be proactive. And even if you're not maybe the primary parent of the children, when you have them, education is, important, and you've got to know what they're expected to do, especially if you have them during the weekdays at all. Make sure try to co-parent as much as you can. Don't wait for your ex or the mom or other party to send you information regarding what the school is looking for on e-learning or any other types of assignments. To ask for that information up front, and if you're not receiving it, contact the school directly. Most of the schools that have shut down have issued very specific information regarding how you're supposed to, what assignments you're supposed to be doing, and things that your kids are supposed to be learning during this time. So make sure you're contacting the school, contacting the teachers. Also, don't forget, there are a ton of learning apps and different types of things that you can access online to help with e-learning. Most of us have some type of electronic device limits with our kids normally. I think that, during this time, most parents are easing up on that a little bit. And that's totally okay. But, even if you do have to let up on that, there's so much stuff that you can find online that's very educational. So your kids aren't sort of zoning out in front of an iPad. That's very entertaining for the kids too. So, again, be proactive and Google the information that you need. If you're not getting it directly, if you're not getting it directly from the school already, go ahead and contact the school, contact your teachers, look on the school's website to determine how they're handling these issues while things are closed. Another tip is to set up a schedule. I've seen some of these schedules online that just are crazy. And if you're trying to work from home and provide a schedule for your kids, it's good to schedule out. It's good to have kind of an idea of what the kids are going to be doing throughout the day. But don't worry if you can't stick to that completely. Everybody, if you're trying to work from home as well, you might have meetings, you might have other things that are going on. So it's not the end of the world if you don't stick to a schedule. But it is a good idea to have a schedule because kids, respond well to structure. And that's why, schools work so well because they do respond to that structure. So try to provide that structure as much as you can, but also, ease up on yourself and on your kids and know that this is all new for everybody and it's just not going to go perfect.
And just because the school itself is closed, but that doesn't mean that there's no access to the teachers, right?
Oh, absolutely. I'm getting emails from my teachers, from the teachers at my child's school 3 or 4 times a week. And I'm in constant contact with them relating to what, things that my kids need to be doing, questions we might have. I even send in, copies of their assignments. So, and really that's great evidence. If you're going through a custody fight or you're planning on thinking you might, the emails back and forth with the teacher showing how proactive you're being with respect to the e-learning and respect to their homeschooling is going to be invaluable information. So don't just rely on someone else to come in and tell you what you need to be doing. Make sure that you're proactively doing all of those things and getting the information your kids need and working with them and documenting that endlessly. Make sure you have a lot of documentation as to what efforts you're putting forward to make sure your kids are being educated at home.
Kelly, there's guys out there that are listening and they're thinking, okay, this is great. However, my wife or my ex has primary or the most of the custody. And how do I ensure that, one, as you suggest, communicating and being proactive, how do I make sure I'm on the communication chain with my school? And two, how do I make sure I stay involved in this e-learning? This is different. How am I going to make sure I get the assignments? And when I do have custody, how do I make sure that I can just stay involved? Because it's so important if I'm in the middle of a divorce that I can show that I'm an interested parent. So that, these are where guys are. They're probably wondering, how do I just do this in this era of a shutdown, a school closure, and COVID-19?
Well, I think the first step is to attempt to contact the co-parent, the other party, ask for any information that they might have already received from the teachers, from the school. You know, is there a class link? Is there some other program that the school is using that you need to know about? If you're not getting a lot of responsiveness, if there's not a lot of co-parenting going on, you have every right to contact the teacher and contact the school directly. The schools are open, kind of like the courts. They're just, people aren't there, the students aren't there in person, but the teachers are still working. So you have every right to get that information directly from the school, and you should make sure that, you know, teachers understand when parents go through the divorces. They understand that happens quite frequently with their students. So this is no surprise that they have to send information to parents. So it's okay to let the teacher know, hey, you know, I'm just not getting a lot of information. Can I go ahead and get on this list? Can you please go ahead and send me what's being expected from my child as well, so that when I have possession, I can make sure these things are getting done. And then just during your time, you know, making sure that on that day that whatever assignment is supposed to be is getting done. And if you don't have that information, or if there's problems, you know, find other mechanisms of making sure your kids are getting some educational information. So again, find those apps on the iPad that you can use for educational purposes. Go and see if you can download worksheets and different types of learning materials. You know, we did something before all of the e-learning came out with my daughter, is I had her watch a nature program, and then she had to write an essay about what she saw in the nature program. So there's reading to your kids. I mean, that's just really important. And of course, you know, the different age ranges, it's going to depend what you're doing with your kids depending on where they are in age. So, you know, younger kids might not have as a difficult or have as much of a curriculum that they need to follow as maybe older kids that are in high school and are in sort of more advanced subjects. So know what your expectations, the expectations are for your child in school, what they're supposed to be learning, and focus the homeschooling and the e-learning that you're doing at home to those goals.
You know, another point to make, just to kind of add on to what you were saying, even if right now is not the time to file the motion to modify, or if you're wanting to try to get increased time with your kids, we're seeing a lot of questions starting to come in. What can I do to put myself in a better position? And Kelly, you touched on as far as the involvement you have with your kids in school. I would also, and I'd be interested to see what your thoughts are on this, creating the lesson plans, writing it down and sending it over to the other parent to get their input on it as too, so you can show that you're actually co-parenting together and you're taking that extra proactive step to remain active in the children's lives.
Absolutely. You need to document everything that you're doing. And that's why another reason the schedules were so great, because it shows that you've taken that advice, you're trying to do scheduling, being able to document the back and forth, even if the other party isn't responding, having those emails to them saying, hey, I'm trying to work with you and trying to do something that's for the best interest of our children is great evidence to have if you're going through a custody matter. I always kind of say, think about everything that you're doing is going to be in front of a judge if you're going through a custody matter. So, documenting what you're doing throughout the day. Again, we advise this on a regular basis, but now it's even more important. Journal what you're doing with your kids throughout the day. If you're playing games with them, if you're doing board games, if you're doing puzzles or whatever, write that down, so you have a documentation that they're not just sitting around playing video games all day and that you're actively working with them. And just document and journal and make sure you've got that evidence, because this is a great time to build your case that you are, primary parent material, or if you're not going after primary, then your, the possession and access should be more. So this is a great time to just document that involvement and make sure that you can show the courts how active of a father you really are.
This goes right into, Kelly, it's a viewer question that they submitted, really kind of goes into, and I'll turn it over to Rick up in Pennsylvania to answer, really, because I think e-learning really goes well with this custody issue. And one of the questions was, with school closures, how does it really affect where the child stays? Can the weekends be extended? So Custody is a big issue with COVID, and especially guys who are separated from their children. There's this limited travel put in place. So maybe, Rick, what's going on up in Pennsylvania? And really, what do you tell guys if they've got an order in place? What happens? Are they to follow it? Is there some flexibility, especially with this e-learning, kind of a sharing? What's going on there?
So, Scott, I would really recommend that anybody who's in the middle of this, try to follow their order as much as it is responsible to do so. Obviously, if somebody in your home is tested positive or is undergoing testing and that sort of thing, I think it's important to put reasonable restrictions on your order. But there's also the potential for opportunity here. And that goes back to what I said about knowing your order or your decree. A lot of times there are contingencies in there, like when there is no school, somebody gets an extra weekend. When when summer vacation starts, now we've seen some states have canceled school clean through the end of the year. So effectively, summer vacation has started, and there's an opportunity for more time for the summer parent to have additional custody time. I'll kick an example out to you guys in terms of opportunity, because I think Kelly touched on it a little bit ago, is so many of our clients are what we would call here in Pennsylvania a partial custodian, and they tend to have an uphill battle when it comes to modifying their custody order. A lot of times because kids are doing so well at school that the courts take the position of, if it's not broke, we are not going to fix it. So they have good students in school, and maybe dad is just not the typical school-time parent. And even though he wants that opportunity, he's not getting that opportunity because they don't want to mess with something that's working. Now, with this remote education and the remote access stuff, it's an opportunity during the school year to exercise that custody time to sort of prove that you can be the academic parent and set yourself up for something in terms of a modification down the line. So once that gets working and you have the evidence in place, maybe then you start to look at filing your modification, getting that in the pipeline, and working on something for when the courts fully open back up for in-person contact and for the non-emergent items.
There's thousands of guys watching, and I know a lot of them are saying, you know what, ever since this shelter in place, my wife or my ex-spouse has gone off the rails on the issue of keeping them safe and not letting me exercise my custody. Rick, what do guys do? We can talk about Pennsylvania, and I'll turn it over to California in a minute, but let's just say, I know there's a guy out there right now who probably hasn't seen their child in accordance with the written order. What can they do in Pennsylvania right now in light of the school being closed, in light of the courts being closed? Give them some help.
You can absolutely file an emergency enforcement action. Most every county in Pennsylvania has come up with some exclusion from the court closure for emergency custody issues, whether that be contempt or enforcement for custody, that there are measures put in place through their emergency electronic access program statewide that allows us to have access to the courts for emergent behavior. And quite honestly, when it's the other side who is causing these issues, they tend to take more seriously the idea that it is in fact an emergency rather than if it were some modification or Band-Aid or something that we might otherwise look at as being, a little more conservative or stringent on the idea of an emergency. We can file that. A lot of times right now, we actually have greater access to the courts for emergencies because they're not backlogged with the in-person trials and the hearings and conferences that have all been canceled now, that we could have these heard within a couple of days instead of a few weeks, which was your prior status quo for custody enforcement emergencies.
Before we go out to California, Kelly, I'm just going to come back to you because this was another question from a viewer. So, we always think about, when we think about family law, and we've been talking about it, we're really thinking about parents that still live in the same city, or they live in the same state, or even in the same home. But, we've got a viewer out there who is living in Texas. His spouse or ex-spouse has moved to California, Kelly. So the question is now we've got perhaps a lot of these airlines canceling flights. Perhaps there's some health issues, worries, concerns about putting a child on a plane. How does this client, how does this guy exercise his rights? And let's just assume for the moment that he's being denied these rights. What can he do in Texas? Assume Texas has got jurisdiction. What does this guy do?
Well, I mean, I think the first thing is to come up with alternative means of travel. So, a lot of the orders, especially in Texas, have allow for flights, but the possession and access actually is the exchange at a parent's home. So, if the drop off is at one home and then there's another drop off, there's nothing preventing driving. And I know that's a long trip, but again, the Supreme Court has put out orders saying the possession and access is supposed to go on as needed and as it should be under a court order. So even if flying is not an option, driving still can be, especially if you have older children. If that's just not an option and flights are canceled and there's just no way to do a plane and keep social distancing, then you can always look at if you're even being denied that possession and access, and you need to file an enforcement at some time. Most judges are willing to do a makeup session in enforcements. So part of what we do with enforcements and when parties miss possession is when we can get back into court, we can ask for makeup time for the time that was missed. And so hopefully what we're looking at is, hopefully this won't go on too much into the summer. Most parents that live far distances are doing probably one weekend a month. So if you can't make that work for one weekend a month, what we're looking at is then longer periods of access for summer. And if that's the case, then driving it becomes less burdensome. And if you're being even denied that time, hopefully by the summertime, we're getting in for an enforcement and we can ask for makeup time. So even more time maybe during the summer than what you were getting if an emergency if we can't get in on an emergency basis.
I'd like to send it up to California, since they were one of the first states to truly enact a stay at home and really restrict what can and cannot be done. And Jason, I don't know if you're seeing this, but I have a lot of potential clients coming in and saying, my wife has the final say with education decisions, and she's not keeping me involved, and she's not letting me see my child because she states, I'm the one who makes the final decision. I'm going to be the one who is going to stay at home and do the homeschooling, and you have nothing to do about this or say about this. What can this dad do?
So I would echo a lot of the comments that we've had from our fellow panelists. I mean, number one, document what's going on. In California, on almost every issue, there are meet and confer obligations of the parties before you seek court intervention. So documenting those communications, letting the other side know that you want to be a part of the solution here, and really taking a common sense approach to your proposed resolution. Yeah, that may not be an emergency issue to a lot of courts given the current status. But there is a day of reckoning for these types of behaviors. Most of our clients, even if there's an unequal timeshare, they are joint legal custodians, and what that means is that there needs to be unanimous decision making on all issues of educational concern. So document. Having a good line of communication, certainly involving your attorney where appropriate, and I would say with an issue like this, it is appropriate to further your concerns. It may not be heard today. It may not be heard 2 months from now, but it does have impact as to your ongoing concerns.
Jason, it's really a good entree to what I think is in your wheelhouse on child support. Before I get into the majority of the questions, and I know the concerns that guys have on child support, if I'm being denied custody and I'm not getting any contact for whatever reason, related to this COVID, is there an opportunity or a way, a mechanism, relief in the court system in California where guys can just stop paying the support until they get the cooperation from their spouse?
Unfortunately, that would be a terrible idea, Scott. Visitation in almost every jurisdiction is not tied to child support. Child support's a consistent. Child support remains in place, really barring a modifying order to the contrary. So taking it upon yourself to say, well, look, if you're not giving me access, you're not getting any funds, that's really going to be nothing but harmful to your case down the road. So I would say that's definitely not a position that I would recommend any client to take.
Yeah, I mean, it's more important to just go file a motion whether it be for contempt or some sort of emergency motion to get the custody, I would imagine, yes?
Well, absolutely. And a little bit about what we're going to talk about today is just the economic impact and job loss associated with these issues. If there is a silver lining to some of these staggering job loss numbers, it is that some of our clients and a lot of folks out there are going to be in a better position to not have their jobs interfere with their available time for visitation. So, that certainly is a matter of significant concern, that if you've lost your job or if you've had a significant reduction in your available work, or you're not an essential employee and you're stuck at home, this is now is the time to be documenting your efforts to be as involved in your child's life and their education and their care as any other time.
So it's a good point when we talk about just child support, because it is the most pressing, whether it be child support or alimony or maintenance. Because, with today's job numbers, with over 3 million unemployed and seeking unemployment benefits, it's just devastating. And I know it's really a call to action for a lot of guys out there right now, because they're really, in my mind, Jason, there's 4 areas or 4 scenarios that we're looking at. That is, we have guys that are furloughed. We have guys that perhaps have received a decrease in pay, decrease in overtime, even perhaps an elimination of a bonus that they were expecting to come, or a delay. And then worst of all, they have guys that have just now lost their job. We've got, I would say, a majority of that 3 million has to be in the food industry and restaurants, and are, those workers, terrible. So the question that's pressing across the country right now, and we'll take that worst case scenario. If a guy's watching right now, they've been notified that they're out of a job, they've got a child support or an alimony obligation. Can they do something? Should they do something? And must they do something right now?
Well, absolutely. So there's a lot of common sense things that every individual affected by this should be considering. So if you're facing a job loss or a wage reduction, one of the first most practical things that you can do without involving an attorney is to approach your employer and ask them if they will provide any type of qualified disaster relief payments. So typically when an employer provides any type of compensation or benefit to an employee, that's going to be a taxable event. However, there are provisions in the federal code and the Internal Revenue Code, as well as in many states' associated revenue codes, that allow for employers to provide to employees, when there is a disaster declaration, such as there is nationwide, qualified disaster relief payments. If that doesn't work, certainly consult with an attorney. You likely have modification rights available to you as to your ongoing child and spousal support obligations. It's important to talk to your opposing party about the reality of the situation. Let them know, I've been affected by this crisis that's out there. My hours have been cut. My overtime is no longer available, or I've lost my job or have been furloughed. There is a standard that's required if you're going to seek the relief of the court. One important point that I do think that's important for all of our listeners out there to understand is that if you have some type of a handshake deal, or in times of COVID-19, maybe an oral deal of, you reach out to the other side, they say, that's fine, I understand, no child support for the next month, we're good. That's not enough. That is absolutely not enough. You absolutely need to have some written, notarized agreement that is then submitted to a judge to be made in order of the court. I can't tell you, Scott, the number of prospective clients that I've met with over the years that have had that exact situation, to where they have, they've had a reduction in their pay. They think that they're on the same page with the other side. Everything's hunky-dory, and then 5 years later, they find out, gosh, I've got a $30,000 or more child support arrears. This is a situation where if you've been affected, certainly have that conversation with the other side. See if you can reach some stipulation and understanding. And if you're fortunate enough to do so, memorialize that and contact competent legal representation to have that incorporated as an order.
Yeah.
Hey, Jason, what about when guys come in and the remedies sound good, but they don't have the ability to continue to make these child support payments? What would you suggest in the interim if they're not able to get something in writing from their ex-spouse regarding the support payments?
Well, there's 2 things. Number one, pay what you can. Taking it upon yourself without any filing to just voluntarily reduce your payments or to make no payments is a terrible idea. Almost every jurisdiction has state mandated interest, and in some jurisdictions penalties to arrears. So if you just take it upon yourself and you dig your head in the sand and just say, I've lost my job, I can't make payments, and I'm not going to do anything else, you're creating an enormous issue for yourself down the road, an enormous financial issue. So that way, when you do resume employment, your license might be suspended. The other component of this is do I wait? Do I wait for things to rebound, or the courts are closed? Can I really do anything? And I would say emphatically, the answer to that is no. You should not do nothing. You should absolutely take action. And there's really three reasons why taking immediate action makes a lot of sense. And by immediate action, I mean making a filing with the courts, even knowing that it's not going to be heard for some time. Number one is retroactivity. The date that you submit your request to modify your support obligation, generally speaking, is as far back as the courts can go. If you wait 2 months to see if this situation improves, maybe you'll get that modification, but it may be a modification to what your status was in May, June, or July. Number two is the anticipated backlog. In most jurisdictions, we have a 60 to 90 day turnaround time to get into court. But what we anticipate is that when each of our counties kind of reopen the floodgates and we're dealing with 3 million plus job losses, many of those folks have some type of obligation. There's going to be a rush of ongoing litigation. In addition to all these hearings which have been postponed for the months of March, April, and potentially May. You don't want to be at the end of that line, and retroactivity certainly is not a guarantee. And we may be looking at a six plus month wait time to have your motion heard. And if the court uses their discretion to not apply retroactivity, and you don't get that, you're going to be at the end of the line for your modification. So taking action now is incredibly important. Third point of this is the existence of withholding orders, wage withholding orders. In most jurisdictions, child support or spouse support obligations are subject to an automatic wage withholding order. So if you've been fortunate enough not to lose your job, but you've had a reduction in pay, that wage withholding order will continue. And it's going to continue until it's modified. Taking action now is the best proactive step that you can take to protect yourself and your economic circumstances in moving forward.
And I'm sure this would apply to the individuals who come in that are temporarily laid off, but know they'll have their job back in a couple months, or those individuals who have a temporary reduction in income, but then will essentially receive income down the road. The time between the reduction in income and the time when they become gainfully employed or resume back to their income prior to the COVID issue, is there still relief available during that time period?
It really depends on your jurisdiction. So nationwide, it tends to be that the standard for modification is that there's both a material change in circumstances and that there's a continuing change in circumstances. So in those jurisdictions, the question might be, well, is a 1 month layoff going to be significant enough of a duration of time? The jury's out on that. I can tell you that in California, the standard is only a material change in circumstances. So, one thing that our courts do efficiently is they modify child and spouse support up and down. So even if you're fortunate enough to only be affected for, let's say, 6 weeks, 8 weeks, 3 months, getting in and getting that period of time modified is important. It's going to significantly reduce down your ongoing obligation. And quite frankly, if it's not revisited, that might be your ongoing obligation for some period of time.
Yeah. So let me toss it to Rick up in Pennsylvania. Rick, back in the recession, 2006 and through 2008, my experience in court where we saw quite a few judges being very receptive to the economic times, to the downsizing, the right sizing, the furlough, the decrease in pay, with guys facing alimony support obligations, child support obligations, up in Pennsylvania. What are you seeing now? What did you see then? And what do you anticipate the judge's perspective, when guys are either getting a big cut in pay but keeping their job, which seems to be more permanent in nature, and even losing their job, and they may be in their 50s, middle life, and trying to find replacement income. Those prospects aren't looking very good.
Well, Scott, as far as the Pennsylvania courts are considered equitable courts, they're going to take a look at the entire circumstance. And obviously, many of them have lived through this in the past, and they're going to take a look at, not just what the earnings situation is, but also what the growth in the retirement accounts and that sort of thing is. That, maybe these aren't people that even when they get back to their earnings that they once had, if they ever do, are going to ever be able to recoup what was lost in retirement benefits. Maybe they won't be able to put additional amounts into retirement. That's one of the things that Pennsylvania excludes from their net income calculation is voluntary retirement contributions. So when we start to look at financial planning for divorce, we're not just looking at what's in the account, we're looking at what it's going to take to replenish that up, because an equitable court is going to consider exactly that. How long did it take to get all of this? How long did it take to lose all of it? And then how long is it going to take to be able to put it back? So from a support standpoint, an ongoing support standpoint, I'll absolutely echo the words that Jason had. You got to file your modification immediately. If things change and you don't find it to be financially beneficial to you to move forward with it once the courts get open, you at least have that decision down the road. But Pennsylvania courts are exactly the same way. They're only going to go back as far as that modification filing date in order to do that. And it may end up that by the time it gets heard that the financial situation has corrected itself, but you still may be entitled to a retroactive modification of that time period, 6, 8 weeks, whatever it was in the past. That may result in an overpayment. It may result in a reduction of an existing arrears amount. It may get you that relief retroactively, but it would still be relief in the long run.
So Kristen, Missouri, and I know we're going to pound this into the ground because this is really where all the questions are coming from as it relates to what can I do now to get some relief? I've got this support obligation hanging over my head. Not only that, I want you to speak to the retroactivity part from Missouri's perspective, but we had a viewer ask specifically, which really is a situation that we all can relate and understand. So we have a guy out there whose ex-spouse has tested positive for COVID-19. She could no longer care for the child, so she went ahead and gave dad the child custody during this time. So we're talking probably weeks. So the question is, what does dad do? Does he still pay the child support, even though he's now taking care of the full expenses of that child? And then I want you to talk a little bit about why it's important to file now if you have a change in circumstances.
Sure. So to the retroactivity piece you were speaking of, my state's the same. The courts can only go back to the time that you filed the motion to modify. So it's imperative to move quickly if this is indeed something that you need to pursue. In terms of your question of this guy that ended up taking possession of his kid, my law states that you can't abate your child support and not pay it to mom unless and until the child's been with you for 30 days. So depending on mom's quarantine period, depending on her incubation period, he very well might get to that point where he's at 30 days and then he can stop paying his support until she comes back to court and tries to get the kid back. So that is a really weird circumstance, but frankly, that's the kind of co-parenting the courts are looking for right now, where if something's happening, you guys have to work together to deal with it because the court just can't help you on a day-to-day basis like they could have 3 or 4 weeks ago.
So I talked, beginning of the webinar about the 3 questions about, what can I do, what should I do, and what must I do? And I know I want to turn to Dan and talk about the things that we must do, Dan. Things that come top of mind for me when we deal with guys, and especially unrelated to COVID-19, but so equally important. Last summer and a couple summers before, I know at Cordell we started doing durable powers of attorney for guys out there and their kids. Dan, can you talk a little bit about that and what are the things you think guys must do right now, especially when we're facing with this health crisis?
Sure. So there are a couple of things come to mind. One, going to the durable powers of attorney. That's something that we can offer here at Cordell & Cordell that I highly suggest you take advantage of. Meet with an attorney in one of our offices to review what are your options. That doesn't mean that you're giving up your rights to your child or your children. We just want to make sure that there's measures in place to protect you. There could be a situation where both parents have been exposed to the virus. So who's going to watch the kids? Who's going to make the decisions? So we just want to make sure that if you're in a situation, and not strictly just limited to COVID, any issue that may arise, we want to make sure that there's parameters in place that can protect not just your rights, but make sure that the child or the children are taken care of. Another issue that comes to mind that gets overlooked are wills and trusts. This is a great time to take out the ones, if you have it, meet with one of our attorneys, let's review it. Maybe there's some changes that we need to make. And if you do not have a will or trust, this is the best time to take advantage of it, because we want to make sure that not only the situation with the children are taken care of, but also with your property and moving forward. So there's things that we can implement and put in place in a will, or more importantly, even in a trust, that can protect your financial assets. So we want to make sure that we're reviewing everything. And in this day and age right now, where the market is just so volatile and our accounts are going up and they're going down, we want to make sure that we're protecting those assets too. And we also want to talk about, what do we do with the property you currently have? How can we put that into a trust? What's the best way to protect that? What's the best way to make sure that my kids are protected with those assets? So these are more high-level things that we need to review, but something that is very important that we just don't want to overlook. But what should we and what must we be doing right now? We want to try to maintain status quo with your children. Routine is essential. As you've heard all the panelists say over and over and over again, document, document, document. We advise all of our clients this exact advice, and we advise everyone who comes in to meet with us. The more documentation you have, the better prepared you are. Hopefully the better results you're going to get, because what you have can be very persuasive in court. Let the attorney determine what's important, what's not important. The more information that you can bring to your meeting with your attorney, the more you're going to get out of that meeting, and the better action plan that you're going to have in place. One thing that I want to make clear is, even though courts are restricting what can be heard, that doesn't mean they're eliminating filing. That doesn't mean they're eliminating hearings that can be heard. It is essential and important that if there's any issue that comes up, we want you to contact us right away, get in so we can discuss, does this rise to that level that we need to have something heard immediately? Because you do not want any time to pass where you're being denied time with your kids. It's one of the most important assets that you have, and that is something that we at Cordell and Cordell take very seriously. But I can also tell you this from experience, judges take very serious. And if there's a parent that's going to be taking advantage of the situation that's currently going on, judges will have zero tolerance for that. And we want to be on the forefront and bring that to the court's attention, that the parent isn't looking out for the best interest of the child. They're trying to take advantage of a situation. So that's on the custody side. On the support side, I agree with all the panelists that if there is a reduction in income, make an appointment with one of us. Go see one of our attorneys in the state that you're in to see what can be done. Because all the panelists made very good points that even though you may not get that immediate relief, it can hopefully be applied retroactive. So getting something on file quickly is something that we really want to take advantage of.
You know, I don't want to gloss over the importance of that durable power of attorney. It sounds like such a simple document, and it's not very complicated. And the wonderful thing and the important thing is we can handle that virtually. We know we're doing virtual consultations. You know, one of the things we have to adapt to as a firm is to transition from in-person meetings to virtual meetings. Things like this webinar, it's such a wonderful tool that we're able to use. And so if that's something that I know you need, that you don't have, that you either have college-age kids who are still away, even, you know, the kids that are moving on, you should have a durable power of attorney for them. We can help you with that. One of the things that we've done over the last week is reduce our retainers across the country. You know, that's a tough time, so we're trying to make it easier, more affordable for guys to retain when we move forward. So keep in mind that we're offering those virtual consults for you. Reach out and we can take care of your questions. Now, I know there were a lot of questions we couldn't get to today, so I would encourage you to keep submitting your questions to coronavirus.divorce@cordellcordell.com. coronavirus.divorce@cordellcordell.com. And why is because we're going to continue this on, this educational series. We're going to keep moving forward. We're going to do a series of podcasts moving forward on coronavirus and taking each individual topic and really kind of digging into it so that we can kind of get to more information, more answers, more tools for you. Those will be posted starting next week. We'll continue that series on for the next several weeks moving forward. So that's it for our webinar. Keep in mind that this webinar is going to be posted on YouTube. It'll be rebroadcast for you, and it'll be on demand. We know that a lot of guys out there, although we had thousands of you live today, we know there are more out there that need this information. So I want you to go ahead and feel free to go back out there and take a view again. We're going to again do the podcast as we go, and we'll post that on YouTube as well. I just finished up my series on divorce on podcast. I would encourage you to go find that. That gives some really critical steps to guys and breaking down how divorce works in a 4-part series. So I want to thank our panelists. Thank you, Dan, for joining us. Lexicon, who helped set this up, as well as our studio spot and all the people behind the scenes to make this work for us. Thank you for joining. We hope it was informative. We know we'll continue to bring you the latest information as it relates to guys dealing with divorce. Thanks for joining us. Take care. Be well. Until next time.